Welcome to Sarpy Outlook. My name is Marta Nieves, and today we're going to be discussing some immigration issues with our guest, Shane Ellison, attorney with Justice for Our Neighbors, and of course he's also the legal director. Welcome, Shane.
Thank you so much for having me. It's a pleasure to be here.
Well, would you briefly tell us about Justice for Our Neighbors?
Sure. Justice for Our Neighbors is a nonprofit organization. We provide free legal services to immigrants in the community who don't have the ability to pay for a private attorney. And our mission really is to welcome immigrants into our community by providing those legal services as well as education and advocacy.
That's outstanding. One of the issues that I'd like to take a closer look at is the Deferred Action for Childhood Arrivals, or DACA. If you could tell us a little bit about what that represents.
Sure. Well, the Deferred Action for Childhood Arrivals program was a creation of President Obama, and it was announced first in 2012. And the basic parameters of the program are to provide children who are brought into the United States at a very young age. They must have entered the country at the age of 15 or under, and if they don't have any criminal convictions or things that make them a serious public security threat, if they've been in school, have graduated, or been honorably discharged from the military, and have been present in the United States from June 15th, 2007 until June 15th, 2012, and then thereafter they should be able to qualify for that program.
Well, that's outstanding because these young people really do need some support.
Absolutely.
Also, I hear that the President's action on deferred status is not legal. I hear people talking about that all the time. Would you tell us a little about that?
Sure, sure. My legal opinion is that the criticisms of the President's use of deferred action are really unfounded. The act of granting prosecutorial discretion or deferred action as an exercise of prosecutorial discretion goes back many decades. In fact, every president going all the way back to President Eisenhower in 1956 has used some form of executive action on immigration to provide relief for humanitarian reasons to immigrants.
Very interesting.
And so I think it's important to understand the basis of deferred action. Really, it rests on that phrase I said before, prosecutorial discretion. So what is prosecutorial discretion? Well, it's a form of authority, a legal authority, that any law enforcement body is able to have and use. And so immigration is no exception. It is essentially the prioritization of what immigration laws are to be enforced in a given setting. So if you look at the state of the immigration situation in the United States, we have approximately 11.2, 11.3 million individuals who are inside the country without any kind of status. And the Department of Homeland Security believes that it has the resources, based upon congressional appropriations, to remove about 400,000 a year.
Oh.
So, if there are 11.3 million individuals who could be removable under the law, and they can only enforce the law against about 400,000, in a given year, they're going to have to decide who's a high enforcement priority and who's a low enforcement priority. Now, deferred action is the legal term that we use to talk about low enforcement priority cases. In fact, before it was called deferred action, it was actually called a low priority case.
Interesting. It's amazing the difference language can make, isn't it?
Yeah, absolutely. And so this practice of granting deferred action, like I said, goes back many decades. And so sometimes people think that the president has done something that's unlawful because individuals with deferred action are given the ability to work. They're given work authorization. And it's important to really get clear on the facts and get clear on the law on that point, because the ability for the executive branch through the immigration authorities to grant work authorization comes from a law that was passed in 1986 called the Immigration Reform and Control Act. or IRCA. And IRCA gave, at that time, the Attorney General, now the Secretary of Homeland Security, the discretion to determine what classes of aliens would be allowed to work lawfully within the United States. And it also directed immigration authorities to promulgate regulations defining those classes.
Okay.
And so one of the first sets of regulations following that in 1987 clarified that folks with deferred action are a category of individuals who can be granted work authorization. So this is really an authority that Congress has explicitly given to the executive branch and is in no way interfering or contradicting congressional action on this particular point.
Interesting. It's so important to get the facts on this because there's so many misperceptions out there.
Yeah, absolutely. So another example. A lot of times you hear individuals, and in fact even the lawsuit that we'll talk about a little bit later that's being litigated in Texas courts right now, in the Federal District Court in Southern Texas, as well as the Fifth Circuit Court of Appeals. The plaintiffs in that case are arguing or alleging that immigration authorities, or specifically the president, acted unconstitutionally. Right.
Yes, I hear that a lot.
Right, and so in my view, I don't think that's correct, and the reason why is because this legal authority to exercise prosecutorial discretion, actually comes from Article 2, Section 3 of the Constitution. The Take Care Clause, says the Supreme Court, is where federal immigration authorities, or where federal prosecutorial authorities in a criminal setting have the ability, in fact they're commanded, if you will, by the Constitution, to make those good enforcement priorities. So if they have limited resources in order to prosecute the laws, they're supposed to use them in a way that makes most sense with congressional intention. And so to tie that back to the Deferred Action for Childhood Arrivals program, or the expanded program, the DAPA program, which we'll talk about in a minute, effectively what the president has done, or what the immigration authorities have done, have outlined categories of people who should be a low enforcement priority. Right? Okay. So if we think about it, young kids who were brought here, many of whom entered the United States as toddlers, who have been educated in our schools, who've graduated, who are going to our colleges, who've not otherwise had any kind of run-ins with the law, these are not the kinds of people that immigration authorities want to focus their limited resources on.
Makes sense.
So that, I think, is sort of some of the legal basis or underpinnings behind the Deferred Action for Childhood Arrivals program, or the more recent 2014 DAPA program.
Right, and DAPA, that I understand is the parents of young people who have been born in the United States.
Yeah, that's right. There are a couple of different abbreviations being used, but everyone calls it DAPA. It's either Deferred Action for Parental Accountability or Deferred Action for Parents of Americans. Actually, both terms are being used right now. But yes, so building off of the 2012 DACA program, in 2014, November 20th of 2014, the president announced this new program. And that new program does basically two things. Number one, it expands who would be eligible for the 2012 DACA program by moving up the physical presence requirement so that a larger class of people would be eligible to apply. And it also removed the age cap. So under the 2012 program, only individuals who were under the age of 31 on June 15, 2012 were able to qualify.
Okay.
Under this expanded program, there is no age limit anymore on that.
Okay, okay. Well, I think it's very interesting that we had a law in the legislature, LB 632, and this was to allow the DACA young people to get driver's licenses. And how I understand it is Nebraska is the only state that does not give driver's licenses to the DACA young people.
Yeah, that's right, Marta. After the president announced the creation of the DACA program in 2012, the former governor announced that the state would continue with its policy of not granting any license or other benefit to anyone in the United States without authorization to be here. And so, by the governor's view, kids granted DACA, they were not eligible for a driver's license. Our view was that that was not a correct read of the law. if you look at the earlier version of the law before LB 623 was passed, it made it quite clear that children who or anyone rather who has a work authorization document and a Social Security card would be eligible to apply for a driver's license in Nebraska, and that was the practice. And it wasn't until the state began targeting kids who were granted DACA for denial that this really became an issue. And so it boils down to some technical issues with respect to the definition of lawful status. And the state had argued that by lawful status they meant the definition as used for determining eligibility for a technical immigration benefit, whereas the plaintiffs challenging the state's position had argued that it was the definition of lawful status as derived from the Real ID Act. That was the definition that should have been used. The Real ID Act is the federal law that the state of Nebraska implemented in passing the original law to say who should be eligible to get a license. And the Real ID Act was quite clear in saying that individuals with deferred action would qualify. But that legal issue is really not alive anymore because of LB 623, right?
Right.
And LB 623
Wonderful.
makes it quite clear that it was the definition of lawful status from the Real ID Act is the one that we intended to use all along, and so now, fortunately, these children who up to this point have been denied a driver's license in Nebraska are now eligible.
It's pretty exciting, and I know that the governor vetoed the bill, and there was pretty much a historic 34-10, what is it, overturning of the veto.
That's right. Yeah, that's right. I think there was tremendous support from the community for these young people. It wasn't only the right thing to do because, as you said, 49 other states already granted driver's licenses to these young people with deferred action under the Childhood Arrivals Program, but also because of the benefits to the state. I mean, there are public safety issues. We want individuals who are on the roads to have driver's licenses. We want them to be able to get insured. This is in everyone's best interest.
Absolutely.
But there were also economic benefits to be reaped as a result of changing the state's policy. So economists estimate that over the lifetime of DACA recipients, their average work span, that it will result in $1.6 billion in increased tax revenues for the states who have those children working there. And again, remember, these are kids who have gone to school or graduated, so their earning potential is going to be higher.
And this is the only country they really know.
Exactly. For many of them who were brought here as 1 or 2, 3-year-old baby, this is the only country they know. That's right.
Yes.
And so, to end the policy of telling these kids they can live in any other state but Nebraska is good policy, right?
I agree.
And not just the Deferred Action for Childhood Arrivals program, the DACA program would also result in tremendous economic benefit for the states that have individuals who benefit from DACA in their territory. So, for instance, a program that was, or a study that was conducted to analyze the earning potential of the 2012 DACA kids found that 60% of those children who benefited from the program were able to obtain new jobs as a result of the work permits they got, and on average, their wages increased by more than 240%. So this is new earning potential and new tax revenues. So what does that translate then? Those predictions, what we know about that crowd, if we were to apply that to the DACA program that's currently being litigated, economists estimate that the state of Washington would see an increase in $57 million in increased tax revenues. California would see $904 million in increased tax revenues. And Texas, one of the plaintiff states challenging the program, would benefit by $338 million in new tax revenues. So these programs make sense because it's good to keep families together, but it's also helpful for the states because it generates taxes, it generates economic growth.
I think that sort of disputes the perception that these folks are kind of a drain on the economy. If anything, they're a boost because population in this nation is growing older and older, and these young people bring enthusiasm, talent, skills, abilities, and the good work ethic.
Absolutely. Yeah, absolutely.
Yeah, it's just pretty exciting. Anything else that you'd like to share in regards to any of these programs?
Well, it's probably helpful for the viewers to hear about where we're at in terms of the ongoing litigation with respect to the DAPA program, right?
Yes.
Because while the DAPA program was announced November of last year, it's currently on hold. No one can apply for it right now. As I alluded to before, the states of Texas, as well as a number of other states, Nebraska included, as plaintiff states, are suing the Department of Homeland Security to block the rollout of the DAPA program. They brought suit in a very conservative federal district court in South Texas, and were successful in obtaining a preliminary injunction that has prevented that program from moving forward.
That's sad.
Yes, yes. The government has appealed that case to the Fifth Circuit Court of Appeals, and on May 26th of this year, I believe, 2015, the court did not grant the government's request to stay that injunction or to lift that injunction, and so the program remains on hold right now. But as I was talking before, I believe the program is on sound legal grounds. I think it's sound from a constitutional standpoint, from a legal standpoint, and we are confident that eventually, when either the Fifth Circuit, the full Fifth Circuit, or the Supreme Court fully considers the merits of that case, that those programs will be upheld.
That's outstanding. Well, I think it's about time to wrap up. So should any of you viewers would wish to contact Shane and find out more about what Justice for Our Neighbors is doing and get the facts on this very important issue in our nation, you'll be able to get in touch with him at the number that you see on the screen. Any final comments that you wish to make? Shane?
Well, just thank you so much for having me. It's terrific to talk about these issues, and it's terrific to make sure that folks get the right facts, right? There's a lot of misinformation, there are a lot of myths, and it's important for folks to understand what reality is surrounding the issue of immigration in the United States.
Absolutely. We all benefit from the facts.
Absolutely.
So thank you so much. And you are a lifeline for many immigrants who are looking for the American dream. So I am so happy to have you on the show, and maybe we can have you back some other time to talk further about this important issue for our nation.
I would be happy to do it. Thank you, Marta.
Thank you.